Hi, I'm Chip Rogers, and welcome to the AAHOA Educational Experience. We're finishing up our series on franchising and the Universal Franchisee Bill of Rights. If you'd like to learn more about this subject, feel free to go to the website. It's the franchiseebillofrights.org. That's franchiseebillofrights.org. Joining me this week, my guests and good friends, C.K. Patel, who is the co-chair of the Coalition of Franchisee Associations. He's also the immediate past president of AAHOA. Next to him, Laura Lee Blake, who is Vice President of Fair Franchising, as well as Government Affairs and General Counsel, and Alkesh Patel, who is the Secretary of the Coalition of Franchisee Associations. He's also Vice Chair and the incoming Chair for AAHOA. We've talked a lot about these issues, and we've got to the last three, and these are perhaps the three biggest. We'll start with UCK, ample notice of significant change and franchisee termination rights. This is such a big issue because throughout the contract, the franchisor has the ability to just simply say, you're in violation, therefore we're going to get rid of you. And that is a death to the business because, as you said, If you lose that flag, you're probably going to lose the business. So this is extremely important to make sure that a franchisee has their rights protected, correct?
Yes. What this means, this has a lot of detail we can talk about. We can talk about an hour on this particular issue, but in looking at the time what we have, I can just tell you one thing. In the franchise agreement, they use a word called generally. Generally, franchisor has a right to do this. Generally, franchisor, but the generally has big implication in the wording of that in the law when you go to the court, and that's what the franchisors are doing, using that word over and over. They make you do whatever they want you to do after you sign the agreement, which you did not know before you were signing the agreement. So if you come in a financial hardship and if you say that I can't do this anymore because I don't have funding, you're not providing me enough business for that, let me go. They'll say, okay, we'll let you go, but you are paying now liquidated damages, which could be in thousands of dollars, depending on how big the property you have. So that's what this provision talks about. The biggest, another thing I think why we need this in this franchise agreement, suppose today's franchisors, their culture is good. They're treating all the franchisee well. If they sell their franchise system to another company who has not have a good track record, who is not treating their franchisee as well, but these guys are making money as their corporate level, so they're selling the whole system. Now you have to automatically deal with as another franchisor whom you are not liking, and they can impose all kind of things on you. At that time, we are saying that if that happens, give the current franchisee right to refuse to transfer their franchise to another name because they don't like the people whom they have sold the franchise system to, right? Right. So franchisees should have a right to terminate at that time, saying, we don't like you selling this system to this XYZ company. I'm dropping my name, I'm going with somebody else without any penalty. So they should be allowed to do that. And there are a lot of other things, I'll in the essence of time, I'll have Laura Lee and Alkesh elaborate more on that.
Laura Lee, that is something that I guess most people probably don't consider, but the fact is in today's economy, you see a lot of franchisors being purchased by somebody else. So we typically think of a franchisor being sort of the stable part of the equation, but in reality, the franchisor may be changing hands more than the franchisees these days. And when they change hands, you have a new owner, they come in and they implement new rules, and some of these new rules may actually cause the franchisee to be operating at a loss or suffer significant financial hardship. And they ought to be allowed in those certain circumstances to move along freely elsewhere if need be.
And we've seen that in recent years in the hotel industry where certain large franchisors have bought the brand names of others, and it has caused great tension, great uncertainty for the franchisees because they don't have that relationship, and suddenly there are new systems they have to put in place, everything from the property management systems, the PMS systems, to new standards that they're complying with. So it does, and sometimes then they also don't have a franchisee association to speak on their behalf, to raise these concerns. So we have seen where they've come to AAHOA and they've raised concerns, and we've tried to work with them to make sure that the transition is fair. But in the end, we have advocated that if they want out, they should be allowed then to exit the system without paying liquidated damages. And it has worked in some circumstances and it has not worked in others, but we do advocate for that.
And real quickly, following up on liquidated damages so that our viewers know what that means, that essentially means that you're going to terminate the contract, and there was in the original part of the contract an agreement that you would pay a certain amount of money for terminating the contract earlier. I guess the best example I can think of is terminating a cell phone contract. You terminate it, you got to pay a lot of money for the extra months that are left. And so sometimes these things can add up into hundreds of thousands of dollars, can't they?
Yes, it's pretty standard in the industry that if you terminate your contract early, you have to pay 36 months of your royalty fees. That's 3 years worth of fees. And so that sometimes comes to hundreds of thousands. We've also seen other terms, maybe $2,000 per room. So if you have a 50-room property, you're looking at $100,000 in liquidated damages just to leave early. So it becomes a substantial amount. Now, many franchisors, depending on the circumstances, they will negotiate that rate. So you should never presume that you can't do some negotiation, but yet, you know, they're looking, I've seen very few circumstances where the franchisor is willing to walk away without collecting some amount of liquidated damages. So you are facing some serious bucks if you decide that you no longer want to fly their flag.
Alkesh, we've got a couple of minutes before we go to break. I want to talk about franchise termination rights. One thing that help franchisees is if a franchisor notifies you that you're outside the bounds of your contract in any way, shape, or form, that you get a certain amount of time to cure that, so that they don't just simply walk in one day and say you're out, but simply giving you an opportunity to cure whatever may be wrong. That only seems fair.
Yeah, and it has to be reasonable. You know, I think to cure it, if they come, and this goes back with a lot of things that we've been talking about. Let's say that if they are coming with the new brand standards, and the brand standards are where it requires significant amount of investment, and as you know, we are not in control of economy, and right now the times are tough, and when the funding is not available, it doesn't matter what do you do. When you had a property that you built, or when you refinance it or you bought it, you already have a first lien on it, and with the current conditions, when you can't get a new loan, forget about getting a new capital for anything. So when the new brand standards are put in place, which requires a significant amount of capital, which you try to go and find, and you made a reasonable effort to do it, and if you still are not able to do that, then you can't be terminated, because you have tried to go out and find the funding or do what you want to do. But as per the contract, because the brand standards were put in place even 6 months, 12 months, and you did not finish it, then you are terminated, and then now you're facing, you know, the liquidated damages. So, you know, the other thing about it is industry standards is you have 4% reserve that the bank required you to put in. I mean, the franchise, bank and franchisor as a reserve. So even if you go with that, the brands, the standards that they're coming up with now, that requires more than that.
4%.
So even if you have put a reserve in place, you have the money, but the standards they're coming out with are so require so much capital that you can't go and find it, even though you use your reserves. So now you're in default, and you terminate it, and then you're looking at paying heavy liquidated damages. So after doing everything that you can, you still get terminated and you face liquidated damages.
I can see the problem there. We're going to hold on a second. We're going to talk more about this because we're out of time here in the first segment. But we're talking about termination rights and parts and portions of the Universal Franchisee Bill of Rights. And we've got a lot more to talk about in the second half of this show. So stay with us. We'll be back right after this. Welcome back to the AAHOA Educational Experience. I'm Chip Rogers, and we are finishing our discussion on the Universal Franchisee Bill of Rights. C.K. Patel is with me. He is the co-chair of the Coalition of Franchisee Associations that put this together. One of the major issues, C.K., is termination rights, and how does a franchisee have their rights protected so that a franchisor doesn't terminate them basically on a whim?
Right. There are so many different ways you can negotiate in your contract agreement. The one thing where Alka said it very well, you put 4% in the reserve, but they ask you to do more than what you have in the reserve, and they put you in default. And if you look at all this, majority of the franchisors are publicly traded company. If you look at the stock market right now, the reporting what they're doing, every quarter they're making millions, they're showing profit. As a franchisee, we know that our business is down. So where does that profit comes from? It comes from all these different fees what they charge to the franchisee. And that's what needs to be stopped. That's what needs to be stopped. Return on investment, that's what AAHOA is doing. That's one of the projects AAHOA is doing. We are conducting a study on return on investment right now. That if you invest so much money in this franchise system, knowing the agreement what you have signed and what you do above and beyond what you have signed, because of these generally kind of words and everything in the franchise agreement, what is your return on your investment after 3 years of staying in the business or 5 years of staying in business? I can tell you about 20 years ago, there was a rule of thumb that your down payment should come out within a year and a half or two. Nowadays, that's not true. Because all the taxes are going up, all the utility costs are going up, all the mandates are going up, franchisors' mandates are going up. Franchisors are mandating all the giveaway, freebies, free breakfast, and all those things. And they're counting the money on the top line, gross revenue. They're not giving any subsidy for this. So the termination, I mean, it's a big issue right now. We need to work on return on investment. That if you don't provide this kind of return on investment, we should be able to walk.
Laura Lee, following up on that, let's say you are in a situation where your franchisor notifies you that you need to fix a few things, and you then take the steps to do that. You cure whatever problem existed. It's only right that then your full rights under the initial agreement are fully restored and in effect from that point going forward, but that's not always the case.
No, and we've seen examples over the years where, and we call them gotcha clauses, because what it will say in the franchise agreement is that if you are in default, even at times if you've cured the default, you have lost important rights under the agreement. For example, the right to exercise what we call in the industry the window. Some of the franchise agreements have 5-year, 10-year, and 15-year windows. And what that means is if you have a 20-year agreement, at year 5, if things aren't going well and you figure, I don't belong in this market under this flag, you have the right with adequate notice to terminate without liquidated damages. And so over the years, we have seen situations where somebody maybe just opened their hotel, they ran into a default. They maybe they didn't have all of the products in place. The QA, the quality assurance inspector, showed up. They found them to be in QA default, and they cured it as quickly as possible. But 10 years down the line, they want to exercise their 10-year window, and they're told, no, you can't. You were in default in year 1. Even though you've operated a perfect property over the last 10 years, we got you. You can't exercise that window. So that's what we're talking about here. That once that you're given a reasonable opportunity to cure the default, and once you do, then you don't lose your rights under the agreement.
The last item on the Bill of Rights, fairness and dispute resolution. Let's say all of these things come to fruition, and unfortunately you've got to solve this in a court of law. It's only fair that the dispute resolution proceedings take place in the venue of the franchisee, so that the small business owner in Oklahoma City doesn't have to fly to New York City to go to court in New York City against his franchisor. That only seems fair. Yeah,
absolutely. And as these are the small business people, and like I said before, you have these business owners running these properties day and night. They need to be at their properties, and by having these in agreement, they have at least fair chance to go and defend themselves in the venue of the choice. So this is very important to have it.
And one other point as well, CK, mandatory binding arbitration. This seems to be something that sounds good, sounds like it's going to work,
right?
But in practice, it's not so smooth.
Yeah, and the reason it is not smooth because normally franchisors ask you to use certain arbitrators whom they like. So if you see the results, majority of the time it's in their favor. And like Alka said, a small business owner cannot leave the business to go to their corporate. It should even have a jury trial in it. It should not be removed. Those rights has to be there. And the franchisor needs to come to you where your business is located if there is a dispute in the business. And this is where I think state government needs to look at also, that they should mandate in their laws that if any franchisors has any dispute with the people who does business in the state of Georgia, suppose, they have to come here to fight the issues. Their business people don't have to
Right.
go to their location. So I think state government needs to look at this also, because it is very important. The dispute resolution, normally arbitration, the reason a lot of franchisors are going for arbitration is a good thing, but the mediation is better. Mediation is non-binding. So suppose if you don't like the mediation, what the outcome of it is, you can still go and sue the franchisor or vice versa, right? But in your state, and that's what needs to happen in this particular clause.
And Laura Lee, to close this out, the last thing about mandatory binding arbitration, again, no AAHOA show would be perfect without a sports analogy, so we're going to give one here.
Yeah.
If two teams are going to play a basketball game and one team said, I'll take care of hiring the referees, you're going to be a little concerned about that.
Right.
And essentially that's what's happening here, is that, yes, arbitration sounds good, it keeps it out of the court, but if the other side gets to hire the arbitrator, it may not be exactly fair.
Right, and there's many concerns about the mandatory binding arbitration. While at first it sounded like such a great option because people thought it would be cheaper and faster than going through the court system, we have found that it is not, because you pay a lot of money to these arbitrators. And usually the arbitration group is set in the franchise agreement, as well as the fact that you have to do it at a location basically in the backyard of the franchisor. So there's no room for negotiation on this. The franchisors that are mandating binding arbitration are not willing to negotiate it. It's take it or leave it. The final thing that happens to franchisees is sometimes they then are precluded from getting the best legal representation because the attorneys that are willing to take on these cases, they say, I don't know if I want to go to arbitration. I can't get punitive damages, and I can't get a share of fees from things like punitive damages that I could get in court. So it raises many, many concerns for franchisees.
I see much of the time franchisors like to go on this route. So if you go to the court, they have to record that in UFDD, that how many cases they won and lost, what was the sequence, what are the issues they've been going to the court and stuff like that. It can look bad on them. So if you see majority of the franchisors, after all, they just negotiate and then they tell, okay, you don't tell anybody this big secret, right? And you keep quiet, we are just making a deal with you. So it does not go under UFDD to educate the newcomers that whether these franchisors are good or bad or ugly.
Right.
So.
Well, we are out of time, but this has been certainly an informational experience, to say the least. For Alkesh Patel and Laura Lee Blake and CK Patel, I'm Chip Rogers. If you'd like to learn more about this subject, you can do two things. You can go to the website, which is franchiseebillofrights.org. That's franchiseebillofrights.org. Or you can send me an email, chip@AAHOA.com, chip@AAHOA.com. Until next week, so long. We'll see you again.